Fantastic. Great. Thank you, everyone, for joining us today for this session on restructuring teams and managing change within organisations. I've got with me today Sarah Gilzean from Morton, Fraser, who's a Senior Associate in Employment Law, and also Lisa Thomson from Purpose HR. We'll be able to take questions throughout the webinar through the chat function. So if you want to ask any questions, just put them into the chat function. I'll make a note of them, and we will ask them at the end of each speaker's slot. So we'll start by introducing Sarah Gilzean from Morton Fraser. Sarah, I'll just get your slides up and start off.
Okay, well, thank you very much for having me. I'm going to speak to you all about restructuring and redundancy this morning. I'm planning to speak for about 30 minutes. I'm very happy to take questions at any point. I think Kieran's maybe going to save them up for the end. And then Lisa's also going to speak about the HR aspects, and hopefully that will give you a very rounded view, an overview of what's involved in relation to restructuring and redundancies. So without further ado, if we could move on to the next slide, I'll give you an overview of the specific topics I'm going to cover. Great, okay, fabulous. So what we'll look at is restructuring. What are the options in terms of what you might be looking at for your organisations at the moment? What are the alternatives to redundancies? What can be done to avoid them? I look at, if you do need to make redundancies, the different processes that apply. And the big thing to remember here are the differences that are involved if you've got 20 or more redundancies. I look in a bit more detail at individual redundancies, i.e. how you deal with individuals going through the process where you've got 20, where you've got less than 20. And then I'll also touch on how you deal with redundancies in the context of the furlough scheme, which I know a lot of organisations are taking advantage of. And hopefully there'll be plenty of time for questions at the end. Next slide, please. So in terms of options at the moment, you might be looking at major changes that need to be made to your organisations given the current situation. You may have been closed, you may have been operating on a reduced basis, you may have had to change your functions entirely. So what are your options in terms of dealing with your employees and continuing their employment? Well, I'm sure a lot of you are taking advantage of the furlough scheme at the moment, which I think has been a lifeline for a lot of businesses, but it's not going to last forever. So what can you do to make the most of that? You may be aware that the furlough scheme has changed. As of the 1st of July, you can now take advantage of what is known as the flexible furlough scheme. So from the 1st of July, you can either keep staff off and claim 80% of their salary back, or you can have them partly furloughed and partly back at work. I would urge you to get specific advice if you've got a particularly complicated arrangement that you want to put in place, but generally what you would do is seek to agree with your employees that they can come back certain hours or certain days and be paid at 100%, and they can be furloughed for the other part of the time, and they can be paid either the 80% that the government will fund, or you can choose to top that up if that's something that you've already been doing, but there's no obligation to top up people that are on furlough. So you might have a mixture. You might have people completely furloughed, you might have people completely back to work, or you might have people on the flexible furlough, and that flexible furlough can change week to week as long as you are keeping in touch with your employees, and as long as you've got agreement to the pattern that you're trying to have them working on. So that's certainly an option that a lot of businesses are starting to take advantage of. It only applies if you haven't furloughed people before the 1st of July, you can't start furloughing them now. But if you've had someone on furlough for at least 3 weeks before the 1st of July, you can furlough them again, either entirely or on the flexible basis. The only people that can go on furlough after the 1st of July who haven't already been on furlough are people that have been off on maternity leave paternity leave, shared parental or adoption leave. So you've got a bit more flexibility with them. If they're due to return after the 1st of July, they can still be furloughed, but they're the only group who can come into furlough if they haven't been furloughed before. You might also be aware that the government subsidy will start to reduce as well. So the government will still cover 80% of wages and NI contributions and pension contributions in July, but from August employers will have to cover NICs and pension contributions. From September, the government subsidy will reduce to 70%, so the employer will have to top up the 10%, so the employee gets 80% in their hand. And from October, it will be 60% from the government, 20% from the employer, to top up to the 80%. And then post 31st of October, it would appear that will be the end of the scheme, although watch this space, as there's been constant developments in this area since March and since the scheme was brought in. So that's really the limited assistance that employers have got. So you, along with many other organisations, are now starting to look at what can be done. Can we continue the costs of furloughing? Do we need to start making more permanent changes? Have our operations been severely affected by the current crisis? Other things you might be looking at are changing terms and conditions. Can you get people to reduce their hours, either on a temporary or a permanent basis? Can you look at them changing their functions temporarily? The most important thing to remember if you're looking at changes to hours, pay, or any of those sorts of things are, ideally you want to be doing it with their consent. A change to their contract should be done with agreement, otherwise you're in breach of contract, and potentially you're also at risk of unfair dismissal if that change is fundamental to the nature of the contract. If you want to change somebody's hours, they don't agree to it and you impose it, that's a breach of contract and it is potentially an unfair dismissal too. So what you want to be doing is getting that agreement. The best way to do that is in consultation with the employees, so they know why you're proposing it, and what the reasons are, and the length of time that it might be in force for, etc., etc. If you can't get agreement on a voluntary basis from employees, then you might need to look at dismissing them and re-engaging them on new contracts. Again, that's what we would call the nuclear option, but in some circumstances, employers need to look at doing that in order for the business to survive. What you need to be careful of there is if it looks like you're not going to get agreement to these changes, and you might need to dismiss and re-engage at least 20 of your staff in order to get these changes through, that will trigger collective consultation obligations because it's treated in law as a collective redundancy. And I'll come on to what those collective consultation obligations are, because they're fairly onerous, particularly if you're a small organisation. So you really want to avoid dismissing and re-engaging people to enforce contract changes. You really want to do everything you can to get these changes in by agreement. In terms of reorganisation, what if you need to reduce the number of jobs? What if you need to change who does what and where they do it from? Do you need a reduced number of people, or do you need functions to change? These are all likely to be termed a redundancy. So you're going to have to look at a lot of reorganisations as redundancy scenarios if the jobs that people are doing are fundamentally changing or disappearing altogether. So you may need to be looking at following redundancy processes, even though you might need the same amount of people, but you might just need them to do things slightly differently. But if it changes the nature of their job, then their old job is redundant, and you need to be looking at it from a redundancy point of view. So that's what I'm going to do now. I'm going to look at what you need to do in relation to redundancy. So that's, just go back one, please, Kieran. That's a definition of redundancy. So as I say, it's quite a wide definition. It's not just where a business closes down. It's not just where you need to reduce total numbers. If you have a diminishing requirement for particular work to be done, either you need less of that work to be done, or you need fewer people to do it, or you need to change the location in which it's done, then that can all fall within the definition of redundancy, which triggers certain rights for the employees to a redundancy payment if their job no longer exists. And it also triggers obligations in terms of how you should run the process to avoid unfair dismissal claims. So basically, what you're looking at is anyone's job ending for a reason that's not specific to them. It's not because of their performance, it's not because of their discipline issues, it's not because of their mental or physical health. It's to do with an organisational reason that their job is coming to an end. It's likely to be a redundancy situation. Next slide. So in terms of what you really need to be aware of is a numbers game. So for many organisations, they will never have had to look at redundancies that might affect 20 or more people. But unfortunately, the nature of the current crisis has meant that even small and medium organisations might be looking at fairly high numbers of redundancies. So if you think there's a risk that you might have 20 or more employees being made redundant, then you have obligations to collectively consult. And these obligations arise at quite an early stage. It's when you are proposing redundancies of 20 or more. And the timescale within which you propose those redundancies is within 90 days. So if you think at any point in a rolling 90-day period, you might have to make 20 or more redundancies, then you need to seriously consider collective consultation. And I would urge you to take legal advice about how you should go about that. I'll just run through the basics of collective consultation. It could be a subject of its own seminar, but I'll just run through the main headlines for you now. Your basic obligation, if you think you're going to hit that 20 proposed redundancies within 90 days, is that you must consult in good time. The minimum, and I stress minimum, consultation periods are 45 days before you make the first dismissal, where you've got 100 or more redundancies. Hopefully that's a fairly unusual situation, but it is a possibility. And it's 30 days where you've got between 20 and 99 redundancies on the cards. And that's not definite redundancies, that's proposed redundancies. If you're at the stage where you think that there is a possibility of at least 20 redundancies within a rolling 90-day period, you really need to be paying attention to the collective consultation rules. The main things to be aware of are you consult with representatives of the employees first before you move on to individual consultation. If you've got a trade union that's recognised in the workplace, it's more straightforward. You consult with those trade union representatives. If you've got trade union reps, but you've also got groups of employees that are not covered by the trade union, they don't need to be members, they just might be in an area of the business that isn't covered by the recognition agreement that you have with the union. They need to be given the opportunity to be consulted via employee representatives. If you don't have any union at all, then again, the employees have the right to be consulted with via their representatives. If you already have representatives in place, you might have a staff consultative committee. If they have a mandate to be consulted on for redundancy purposes, you can consult with those people that have already been elected. However, if it's a sort of general staff committee that isn't a formal consultative committee and is more of a kind of staff committee that discusses fundraising and social events and that sort of thing, that's not likely to be a formal consultative committee, and you're going to have to give the employees the opportunity to elect employee representatives. Now, there's a whole bunch of rules around electing employee representatives, which I won't go into just now, but just suffice to say that if you think you might be in this territory, to take advice, because you do need to give the employees an opportunity to have basically hold a secret ballot in order to elect employee representatives to represent each kind of constituency in the business. So you might have someone representing management, you might have someone representing a particular department, for instance. So that's quite a big undertaking, especially at the moment where you might need to run elections online and do consultation virtually, because face-to-face is a lot more difficult. So that's something to bear in mind too. The other biggie that you need to have on your radar is the HR1 form. Again, if you think that there might be 20 or more redundancies, you need to submit what's called the HR1 form to the Department for Business Enterprise and Skills. And it's a fairly straightforward form. You can do it online. You just need to be telling the government that we've got 20 redundancies or more proposed here, and they're in this areas of the business. And we've shared this information with the representatives. But if you don't fill that form in and submit it, it's a criminal offence. So you do need to be aware that there's an obligation to do that where you've got this collective redundancy situation. And also, again, if you think they're in a position of having to dismiss and re-engage people in order to push through contract changes, that's the other thing. It's not just redundancies, it's collective changes to contracts that might be a dismissal and re-engagement. So the basics, when you actually you've done all the preliminaries, you actually then need to get to the meat of the consultation itself. And that's where you really need to go into detail with the representatives about the reasons for the redundancies and how many people it's going to impact on. And I'll look at that in a minute. Even if your business is closed, even if face-to-face consultation is not possible, you still need to do everything that's reasonably practicable to go through collective consultation. There is a special circumstances defence for employers who haven't been able to collectively consult in these circumstances. But generally the view is that given the current climate, where employers have had plenty of time to consider whether they need to make redundancies and to make arrangements for putting consultation in place and to use telephone and online methods, that it's probably unlikely that an employer will be able to say, oh, we just couldn't consult, it was just too difficult. So it's unlikely, we think, that you'll be able to say, well, in the current climate, it was just too difficult. The risk of not properly collectively consulting is something called a protective award. That can be up to 90 days pay per employee if you haven't been through the proper collective consultation process. And it will also impact if any of those employees want to claim that their redundancy itself was unfair, then they will use the failure to collectively consult to show that they've been unfairly dismissed. So that's collective consultation. The process on the next slide, I'll look at the things you should be consulting about. And this applies both to collective consultation and to individual consultation. So I'll go through this slide in a little bit of detail, simply because it applies regardless of how many numbers of people you are making redundant. These are the things you really need to be thinking about. When you're consulting either collectively or on an individual basis with people about redundancies, you really need to be thinking about consultation with a view to reaching agreement. So this is not just a tick box, we're having a couple of meetings to say that we've done some consultation, and actually this is just going to happen anyway and it's inevitable. What you need to be doing is starting from the premise that these are proposals and not fait accompli. They are proposals which could still change depending on the outcome of the consultation and what the employees have to say about it. And the things that you're consulting on are avoiding dismissals, reducing the number of dismissals, and mitigating the consequences of those dismissals. So what are the alternatives? Is there any way that the numbers can be reduced? Can we look at reducing the use of agency workers, for instance? What are the mitigating the consequences of dismissals if they really can't be avoided? Can people be given help without placement? Can they be given help with job search? Can they be given volunteering opportunities, etc., etc.? In terms of the basic information that you should be giving either the employee reps or the individual employees when you're consulting with them, are the reasons that the redundancies are proposed, the numbers of people that are at risk of redundancy, the proposed method of selection in terms of how you're going to go about deciding who is going to be dismissed, the method in terms of how it's going to be carried out, what time period will this take place over, how are different parts of the business going to be affected at different times, what are the options for alternative employment, that's a really, really important one, and how are redundancy payments going to be looked at if redundancies can't be avoided. Is it going to be statutory minimum redundancy pay, or is there an enhanced redundancy package on the table? Do you already have a scheme in place? Do you have a policy where you normally pay enhanced redundancy? Or is this something that you're looking at on a goodwill basis this time, that you might pay a little bit more than statutory minimum? So that'll be that has to be covered as part of the consultation process. Next slide. So in terms of individual redundancies, only those with 2 years service qualify for statutory redundancy payment, which I'm sure you're aware, and only those with 2 years service qualify for the right to claim unfair dismissal. So a lot of employers consider the question, well, do we need to follow a fair process for everybody, or only those with 2 years service? Lisa might have something to say about this as well in terms of company values, etc. Certainly my advice is usually to follow the same process with everybody, because there may be people in there who have a protected characteristic, or have an issue in the background that they could turn around and say it underlies the reason for their redundancy, that doesn't require them to have 2 years service to bring a claim. So if someone can argue that they're being made redundant because they've been on maternity leave, or because of their age, or because of their race, or because they've blown the whistle on health and safety concerns, they don't need 2 years service to bring a claim. And if you've treated them differently in terms of process, it will make defending that claim a lot more difficult. So although it might make the process a little bit more onerous, I think there's good that there might be organisational and ethos reasons for doing it too, but I think there's probably a good legal case to be said for following the same process with everybody. Really the basics to consider when you're going down the individual route is you're giving people enough warning, you're consulting with them with a view to reaching agreement on a basis that this is genuine consultation that could actually make a difference to the outcome, and that what you're talking to them about are proposals and not fait accompli. It's not a done deal. This is still all to be discussed. There's no right to be accompanied at individual consultation meetings. Some organisations do it as a matter of course. It's certainly good practice to allow people to be accompanied at redundancy consultation meetings, but there's no fundamental right to that. I would simply say that you should, if anyone asks, if you're not keen on allowing people to be accompanied, but if someone asks to be accompanied, I would consider those requests reasonably, particularly if someone might have a disability or a language need. Then absolutely there might be a more definite need to allow them to be accompanied. So again, something that you might want to think about in terms of process. So next slide. So the main, just sort of continue on the main things that you would discuss at your meetings would be your fair and objective criteria for selection. This I think is what most people get wound up about when it comes to redundancy. People might be in a pool of one, so they might be in a unique role where that unique role is no longer required. And again, the selection of that person is probably not, selection criteria probably doesn't apply to them, but considerations of alternative employment and the reasons why their role is no longer required would really form the meat of their consultation process. Others where you've got more than one person in the same or similar role, that's when it's going to come down to objective selection criteria and potentially using a scoring matrix to select people. And if you're going to go down that route and you've not done it before, I would suggest you get some advice about the criteria that you use and the scoring that you use to avoid making any discriminatory decisions inadvertently for instance, if you used long-term absence as a criteria that might work against someone with an underlying disability. If you're in a situation where you want to have an interview process, like a recruitment process, if you like, for a role, say you're getting rid of 2 roles and replacing it with a new one, that's absolutely fine. You can go down the kind of recruitment role, but you want to be telling the people that would be going for that job what the success criteria are. So rather than the redundancy selection criteria, this is the kind of success criteria for this role, as you would a normal recruitment. In terms of alternative employment, you should be open to people looking for any alternative employment. If it's something that's not close to the job that they're currently doing, they might need to apply for it, and that's fine, and go through a recruitment process. They've got no automatic right to that role. The only time when alternative employment might need to be offered to someone without an interview is where they're on maternity leave. And this is one of the few examples of positive discrimination that there are in the law. And you need to be aware that if someone is on maternity leave, they have the right to first refusal of alternative employment without an interview. So again, if you think that is an issue, but you're not happy with the result that will give you, or you think it's unfair on the other people that might be in the frame, then I would urge you to take advice on that area, because it can be quite complicated, depending on what the type of role is and whether you can say it's actually suitable alternative employment, or whether you could say it's actually so far removed from what this person was doing, you don't have to offer it to them. So again, if you've got that specific scenario, just be alive to it and take some advice on it. There's also the possibility of trial periods as well, where someone has the right to try out an alternative job as an alternative to redundancy for a 4-week period. And if they don't like that job, or it's not suitable for them, then they can refuse that job and still claim a redundancy payment. In terms of entitlements, in terms of if redundancies can't be avoided, that people will, if they have 2 years service, they'll qualify for statutory redundancy pay. As I say, check to see whether you've paid, you normally would pay an enhanced rate. Sometimes employers use actual pay rather than the statutory minimum of a week's pay, to give people a little bit more. Have a look and see what you've done in the past, but the basic entitlement is the statutory redundancy pay based on age and length of service. They'll also be entitled to their notice, either minimum statutory notice if that's all they get, or longer contractual notice. You might want them to serve that notice out, or you might want to pay in lieu of that notice. I'll come on to the options for that in a moment. And the other thing I would also be alive to is how you deal with holidays, because again, do you want to be paying accrued holidays in a bulk lump at the end, or do you really want them to be taking those holidays during their notice to try and save some money? And if you want to compel people to take holiday, you have to give them double the amount of notice of the length of holiday you want them to take. So again, if you think accrued holidays is an issue, particularly if people have not been taking holidays because of the current scenario, just be mindful that you don't want to end up with big accrued holiday liabilities. Next slide. I've put a checklist on there. I'm not going to go through it because I haven't got time, but that's just to give you an idea of really the basics of what you need to be thinking about. I always say to clients, you need at least 2, if not 3 meetings with people in order to do a fair redundancy. And there may be more meetings depending on how much of substance comes out in the consultation that needs to be responded to. And you really need to be thinking about, you're warning people, you're explaining why they've been selected, you're getting their feedback, you're going back to them to answer those questions. More questions might arise, you go back to them on that, then you have a meeting to confirm the outcome, and you also want to be giving them a right of appeal as well. So there are several stages that you'll have to build into your time scales. and just to be mindful of that. Next slide. I just thought I would finish by talking about redundancy in the furlough scheme, because this is relevant to lots and lots of employers. And a question that comes up all the time is, can you make redundancies when this furlough scheme is still available? And obviously it's the first question that employees will ask is, why am I being asked to go now when I could be furloughed till the end of October? And that is a consideration. Obviously this is a brand new area and we've got no case law on what a tribunal would say about whether it's fair to make people redundant when they could have been kept on a bit longer. However, I think given the fact that it's now becoming more expensive for employers to furlough people because the contribution is going to start to rise, and if employers can see that these roles are really never going to come back in the foreseeable future, then I don't think an employment tribunal would criticise an employer for going ahead with the redundancy process where really there is a genuine redundancy scenario, and as long as you followed a fair process. I think a tribunal would want to hear from the employer, however, that they couldn't afford to keep furloughing somebody, and that's why the redundancy process was being started. So just bear that in mind when you're making your considerations and looking at the numbers. You can do the consultation process while someone is on furlough. If you're in a situation where you're having to deal with elected employee reps to do consultation, although they're not allowed to be working, they can be dealing with you in relation to consultation. What I should say actually is that any meetings, they don't have to be face-to-face. You can do all this by phone or by Zoom or whatever works. Just when we say meetings, we mean meetings, I suppose, in the new sense of the word. So you can consult during furlough. You can consult with reps who are on furlough. You can serve notice during furlough. You can claim that notice paid back as part of the furlough scheme, i.e. the 80% can be claimed back, but you can't claim pay in lieu of notice. So if you want someone to go sooner and you're going to pay them in lieu, you can't claim that. You can't claim 80% of that notice paid back from the government. You only have to pay full pay on notice for people working out their notice if they are on statutory minimum notice only. If your employees have the right to more than statutory notice, then you can pay them the furlough rate and claim back the furlough rate. Statutory redundancy pay is worked out on normal salary if an employee has a fixed salary. So you wouldn't work it out on their furloughed pay. You'd look at what their normal salary would have been before furlough. However, if you've got someone who doesn't have a fixed salary and has variable pay that goes up and down depending on the work that they do, their redundancy pay will unfortunately take account of whatever their pay has been influenced by during the furlough period. So you need to be looking at what their pay was on the day that you serve notice to them of redundancy, if they've got variable pay. If you've got anyone in that situation, I would get some advice and double check that you're calculating the redundancy pay correctly. But if you've got someone who's just on normal, who's a normal fixed salary person, you'd look at their fixed salary when you're calculating redundancy pay. And of course, it's subject, if all they're getting is statutory redundancy, it's subject to the statutory cap on a week's pay anyway. Furlough grant can also be claimed for any accrued holidays. So if you think you want people to take holidays during their notice period, you have to pay them 100% for any holidays during furlough, and that counts for any holidays during the notice period. But you can claim 80% back of those holidays whilst that are being taken during the notice period. If, however, you pay holidays in lieu in a lump at the end, you can't claim anything back for those. So that's again something to think about when you're working out with people what they're going to get if they are made redundant. Next slide. So that's really all I wanted to say. I thought I'd just end on a cheerful note with what the consequences of failing to consult, which are unfortunately unfair dismissal claims if someone's got 2 years service. I also touched on the fact that there might be claims if people don't have 2 years service but can complain that their redundancy is to do with a protected characteristic or to do with whistleblowing or health and safety. If you're in a collective redundancy scenario, big red flag, take some advice, because you've got all those extra obligations to think about, and the consequences of not doing that might be unfair dismissal and a protective award, which is almost like a penalty that is imposed on employers for failure to consult at 90 days pay per employee, and that's actual pay. Again, I mentioned the special circumstances defence there, which we think is unlikely to work in the current climate, where employers really probably do have the opportunity to think about and plan for redundancies and use other methods to carry out consultation, and not just say it's just too hard because we can't all meet at the office. So that's enough from me, and I'm very happy to take any questions at the end, and I'll hand back to Kieran.
Brilliant, thank you very much, Sarah. That's fantastic. I've got a few questions that are coming through. I've got one or two on this section, if that's okay, just to clarify before going on to Lisa. So in terms of protected characteristics, in a tribunal situation, an employee can make a claim for unfair dismissal or constructive dismissal if it's based on a protective characteristic. Am I right in thinking it's uncapped? Whereas in terms of the amount they might be able to claim, whereas it's different if it's not for a reason of a protective characteristic. So you really need to be careful.
Yeah. I mean, if it's just an ordinary unfair dismissal from someone with 2 years service, it's capped at a year's salary. Mm-hmm. If you're arguing it was also discriminatory, that year cap doesn't apply, and it's what has this person lost because they've been made redundant unfairly, mm-hmm. plus the potential of an injury to feelings award as well. So discriminatory dismissals are potentially very expensive.
Yeah. And in terms of the negotiations on team hours, obviously you explained very kind of fully about the 20 people kind of cap for consultation. If there are organisations, because I think there will be, that are looking at maybe thinking about reducing hours for a certain amount of time for certain staff, when you're doing those consultations, you might be thinking, well, I have frontline delivery staff who perhaps are needed for this amount of time. I have managers that are needed for this amount of time. Is there any kind of like advice round about how you should be consulting with people so it's seen as being kind of fair? Obviously, you would want to take advice at that stage from a lawyer if you're thinking about certain people's hours going down, whereas other people's would it go down. It's the same sort of consultation process, I'm guessing, you would go through.
Do you mean that you might have different changes for different groups of people?
Yes.
Yeah. So I think if what you're proposing are changes that are not, that you wouldn't need to do dismissal and re-engagement for, you would consult with the different groups about the different changes. So you wouldn't do a collective process with them. You would only look at a collective process if it looked as if you were going to have to dismiss and re-engage because you weren't getting anywhere with the consultation. So you would do consultation with the managers individually about, this is why we need you to change your contract in this way. Mm-hmm. You would do consultation with the delivery drivers individually. This is why we need you to make these changes to your contract. If it looked as if across the board it wasn't going well, and that actually you were going to have to try and impose this change, and the way you were going to do that was to dismiss and re-engage, that's when you look at is it 20 or more? Do we need to now do a collective employee representative process? But hopefully you can get the numbers down under 20, so that even if you're just left with a handful of people who are refusing. And so yes, so you should do it like an individual consultation. You send people a letter, you would explain, you would ask them to respond, and if they were happy to accept, then great. If not, you might want to have a few meetings with them to talk about why they weren't accepting and what the alternatives were. And then if they really still were not happy to accept, you then start looking at, right, how many have we got here that are saying absolutely no way? Because what you might do then is actually do redundancies with them rather than dismissal and re-engagement on new terms. So you would do it that, you kind of do it in stages.
Thank you very much. I'm sure we might have a few more questions towards the end, but it's incredibly helpful. And obviously, as we advise, and this is all this advice is given as non-reliance, and we would obviously advise that you seek you engage an employment lawyer for more support. And Morton, Fraser are our employment lawyers, so thank you for doing that with us today. Lisa, lovely to have you today from Purpose HR. I was going to ask you a few questions on your organisation and what it is you do, and you were going to speak about the kind of softer aspects and the kind of more, well, I guess the kind of people aspects of taking people through this journey, and you had some key themes, I understand, that you were going to speak through.
Hi, Kieran. Thank you. Sorry, I was just unmuting myself there. So yeah, I would just, I guess, like to sort of thank Sarah for all of the, really important compliance and legal points that she's raised, and just, I guess, reiterate the importance of, taking the right advice on these steps and, not getting caught out. These processes are difficult enough for everyone involved without, getting kind of caught out on anything procedural. Mistakes can obviously be, quite time consuming, and it can be costly. So what I would like to do is really just complement some of what Sarah's talked about from our perspective, because we're not employment lawyers, we're HR specialists. So we work essentially mainly with small businesses or organisations that don't have an in-house HR function. So it's a bit more of a hands-on approach that we would take. It's more around maybe the practical and some of the people aspects as well, in terms of potentially being present at a number of the types of meetings that Sarah's talked about, facilitating that, being part of maybe internal communication strategies, and helping managers with what I would say is generally accepted as one of the most difficult and challenging things that you can ever have to do, in your career. So, I think underlining that it's incredibly challenging, obviously, for people affected, because if they are, made redundant, they're losing their livelihood, they're losing, the impact on their future. At the same time, it's actually incredibly difficult for anyone that's having to lead these changes, and be the face of that within an organisation too. So a few of the kind of key themes that I want to talk about, and it was about how can we address and make difficult decisions and difficult challenges, but still remain true to our purposes as social mission driven organisations and our values. So going about these steps in a way that is compliant and meets our obligations and is fair and can be defended if it was challenged, but also thinking of it from the people aspect and the human aspect of those that are affected. So a few themes that I'll just kind of step through at quite high level, and then if you need to ask questions or would like to know more, I'm happy to expand on them. The first one I wanted to talk about was transparency and communication. So, we have a lot of experience of working with organisations, as I said, and taking them through these changes. And what makes a real difference in terms of how affected employees and the wider team engage with the process is how they are treated in terms of sharing the commercials, the challenges that the organisation is facing, and the crucial aspects of that, and how much we can share, treating people involved in the process like adults, and being open about the rationale and how we've arrived at the need to make these really difficult changes. So the more that you can do, the more that we find people will be accepting of difficult decisions that employers need to make. And just kind of aligned to that is I guess, treating affected individuals with respect and dignity. So some of these points, as I said, we tend to work with smaller organisations, so a lot of this is more around one-to-one individual consultations. I'm not so experienced at the kind of larger organisation basis, but when you're in one-to-one consultations with individuals, or we're having to look through either difficult changes to their contract that might affect their terms and conditions, or the prospect of redundancies, I think it's trying to put yourselves in the shoes of the person that's on the other side of the table there and affected. Sometimes we're having to run a meeting and we've got to follow a specific procedure and a script to that discussion because we have to for compliance reasons, but actually we still want to treat that person, you know, humanly as a colleague that we've worked with. So trying to be, you know, respectful, trying to make sure that we approach it so that we understand how it feels like to be at that other side of the table. And I certainly have been at the other side of that table too in the past, as sometimes have many managers involved. The person's going to react in different ways. People might get emotional, they might get angry. And I think a skill for a manager is not to get defensive. So you may feel that it's almost a competitive process, but it really shouldn't be, it should not be. You know, so if the person's asking you hard questions, try and understand where that's coming from and give them answers as much as you can, rather than it become a sort of standoff meeting, because that doesn't help anyone. I wanted to just reiterate a really important point that Sarah made actually about the consultation. So we always talk to our clients about the importance that consultation is genuine. Consultation, so exactly as Sarah said, it's not a tick box. There are proposals that might come out of this that could actually be workable and could avoid the need for redundancies or mitigate the impact. So really be open to exploring and discussing alternatives. And I've certainly seen with clients where other things came up that hadn't been considered before, and we've been able to reduce the impact on the business. So, you know, that is a positive. And also be open-minded. Sometimes actually the organisation might be able to put forward some alternatives that can avoid redundancies, and the affected employees will really value you know, and engage with that much better if it does feel like a genuine and not a, well, we've got to have this meeting because HR said kind of thing. So you know, with that, what I would say is that there are people that, you know, once it reaches this point, they've been told they're at risk and they're attending the consultation, they may say, well, you know, I can see see what's going to come out of this. You know, I just want to know what my entitlements are. I just want to know what happens next. So you know, I appreciate that might be the case as well. And what I would say there, prepare, get your calculations ready in advance, be prepared for that. Make sure you are able to set out, as Sarah said, how it would be calculated, but what the numbers might look like if the dismissal did go ahead, because people are wanting to plan for their future and they want to understand the implications from a financial perspective, as you know, holidays, redundancy pay, all of that, what the implications would be. Another area to think about is actually sort of wider team communications. So you know, I think sometimes in organisations these are difficult, and we want to maybe sort of move the process along, you know, get past it as quickly as we can, you know, and move ahead. It's understandable, you know, but at the same time, I think you really do need to have a communications plan designed up front, not just for those individuals that are affected, but also those that will be remaining within your organisation. Be proactive. You don't want that to be managed through, you know, to get out through rumours or whispers. It's better to be in charge of the message that, you know, and share that openly where you can without breaching confidentiality, of course. I think we have to acknowledge that even those that are staying with the organisation are still going to be to a point affected by this. They may be having to pick up wider workloads, they may be losing, you know, really valued key colleagues, you know, and sometimes we just need to acknowledge that. And if we don't have proactive steps in place, that can actually sometimes have a wider long-term impact for your organisation, so it's important. Just a couple of last points, but making sure that if redundancies do have to go ahead, going back to what I said about being, you know, respectful and treating people as human, it's really key to say that, and it's also true the case that if somebody's made redundant, it's not something to be ashamed of. It's not a reflection of their performance or of them as an individual. It's an organisational change, it's the role, and ideally the employer would have preferred not to lose anybody, you know, I'm absolutely sure. So that as part of your communications is really key, just to have that empathy aspect and treat people with dignity. If the dismissals do need to go ahead, do be thinking about what else could we do. So I think Sarah touched on outplacement or transition support. Obviously, you know, it's budget dependent, but it doesn't always need to be massively expensive. You can have maybe a few hours of time from a professional, and that can make a real difference because it's something positive for the affected employees. It's something to look ahead and be thinking about the future, and it can maybe give them a bit of a confidence boost. So some CV, support, some interview coaching, maybe looking at the market and looking at opportunities, even thinking about a career change for some people. So do consider that if you can. And sometimes we even find gestures like that can be the difference in terms of people appealing or challenging decisions versus actually starting to look forward and look ahead, so it can really pay for itself. And if you can't have budget for an external person to do that, even what can you do? Leaders within your organisation, can you open up your networks? What would you do in terms of references? And do be thinking about, if things change, if it picks back up, let people know that we'd maybe be open to rehiring them or bringing them back. And I guess I'll finish on, if they would be willing to do that and they're willing to come back, that's probably a reflection of how you've managed the process and your brand as an employer as well.
Fantastic, thank you very much. Lisa, it's obviously, like you said, it's one of the most difficult things that an employer will have to do, and especially, well, not especially, but if it's a small organisation, it can have an impact. So I guess, like you're saying, it's not a reflection on performance, and as Sarah said before, it's about an organisational decision.
And survival
of
things,
the
yeah.
organisation. That's fantastic. So thanks very much. I know you do a lot of work with our SIS Ventures cohort, so thank you very much for doing that. I actually had one final question, probably for Sarah, on furloughing. It was just to clarify, I know that recently there was a cut-off deadline for staff members to register or to agree changes within the furloughing scheme. Does that still apply if you have someone in maternity leave, as you said, that deadline probably doesn't stand for them? But I'm just wondering, round about those kind of deadlines for furloughing and that sort of thing, if that's still.
Yeah, I mean, the position is that if you haven't furloughed anyone by now, you're too late, unless that's a person that's coming back from maternity, adoption, or shared parental leave. It would also apply to paternity leave as well, but because paternity leave is so short, it's probably less relevant. So yeah, you had to have had someone furloughed for at least 3 weeks before the 1st of July, well, before the 30th of June, in order to keep furloughing post 1st of July. So if you've not done that with people, then unfortunately you won't be able to make any claims to HMRC for the subsidy for their wages. But if they've been furloughed for at least 3 weeks before the 1st of July, then you can furlough them at any point up until the 31st of October, or you can take advantage of the flexible furlough where you've got them part working, part furloughed. So yeah, that's the main change that came in on the 1st of July.
Perfect. Thank you so much, both of you, for your time. I think as normally with these things, they're so detailed and in depth. People are happy to listen along. What I'll do is I'll share your contact details, Sarah, with anyone, and also Lisa, that is thinking about this at the moment. I know from someone that's had to lead people through this process quite a few times, especially in a small organisation, it's a horrible thing to have to do. And there's a consolation of knowing that you're doing the best by them, but also following the law as well. So I obviously would recommend to take legal advice and then also HR support as well. So thank you very much, and I will speak to you both again. Thank you.
Thanks so much. Cheers.
Bye.
Bye.